I want to talk about Udo v. Garland in the Ninth Circuit. You and I are both in the Ninth, and I mean it's not amusing, right? Because it's it's about asylum. It's about an individual who was beaten for being a homosexual in Nigeria and was caught in a sexual act with his partner in this hotel. The amusing part to me is that he was caught in a lie about the name of the hotel during his removal proceedings. He said it was the Sin Hotel. I'm sorry, he said it was the Sheridan Hotel. And then DHS provided evidence that there is no Sheridan Hotel anywhere close in Nigeria. And he said, no, actually, it's called the Sin Hotel. And he just said Sheridan Hotel because he thought it would be confusing if he said Sin Hotel. I don't know, whatever. And the IJ, they made an adverse credibility finding and made a frivolous asylum finding. Mm-hmm. Like, so IJ threw the kitchen sink at the guy, but the Ninth Circuit came back and not only vacated the frivolous finding, which otherwise would bar him from receiving any relief in any context in the future, but vacated the adverse credibility finding as well, saying, quote, the name of the hotel where Udo and his boyfriend were allegedly caught is not a material element of Udo's asylum application, end quote. The location is at best ancillary. So again, according to the Ninth Circuit, even if he misspoke or even fabricated the name of the hotel, it wouldn't change the fact that he was beaten by a mob after being caught in a homosexual act and the other things. So the Ninth Circuit continues to have, depending on the panel, some very favorable, from some very non-citizen favorable adverse credibility standards. And that applies before that applies before USCIS as well. I mean, go on.
How does the court make that determination? Aren't they not supposed to double second guess the fact finder's finding and stuff like that, or opinion and stuff like that?
Well, like all facts, it's subject to substantial evidence review. Not only that, I mean, this is what I talk about on the podcast all the time. When you're talking petitions for review, facts are substantial evidence review. You uphold them so long as substantial evidence supports them. But a legal conclusion, a legal determination, maybe a mixed question of law and fact, that's reviewed de novo. Is this a mixed question of law or fact? Well, maybe, because the Ninth Circuit has a very clear adverse credibility legal standard. And so if the BIA has not applied the facts to that legal standard correctly, that actually might be a legal claim. Credibility in the Ninth Circuit has gotten very interesting it's always been interesting, but after the Supreme Court's decision last term in Dye v. Garland, where the Supreme Court actually overturned the Ninth Circuit is now saying, okay, credibility determinations require a consideration of all the facts in totality. But as I read it, the Ninth Circuit is also saying, I've talked about this on your podcast, I think, before, if one of the things supporting an adverse credibility in totality was wrong under substantial evidence review, well, the whole totality fails. Because if there are three factors upholding something in totality, you take away one factor, now you have two factors. Well, now the totality might not support an adverse credibility finding.
So it seems that these asylum cases, when there's factual, determinations like that.
I'm sorry, what?
It's always good to appeal as much as possible in these kind of asylum cases if the judge makes a determination on on an issue like that.
Yeah, it's hard. But if an adverse credibility finding is made, no matter what the underlying relief is, but certainly asylum, you're probably going to lose. And so you kind of have to. And these become very tricky. And the Ninth Circuit is certainly leading the way on case law to challenge an adverse credibility finding, again, be it before USCIS or the circuit or the immigration judge.